I first became involved in the Supreme Court in the 1980s when John Young was Chief Justice, and we produced the major conservation management plan for the courts. We then did a major review, and then we've had involvement in much of the refurbishment work over the last 25, 30 years. And so it's a building that I've certainly scrambled over every single space in it and know it pretty well, not recently. What I wanted to do was really walk through, in a sense, a number of issues that relate to the future of this building. And in a sense, this building is increasingly becoming an anachronism, if you like. Like all libraries of this ilk, specialist libraries, progressively over time, they are increasingly being used less because people are accessing hard copy less, all the things you'd be well aware of. And so this library, not unlike the library at Parliament House, not unlike the State Library in practice, there is a whole issue about libraries as repositories for books as opposed to libraries as places to go and research, investigate, etc. And so the future of this library is certainly something that is worth looking at. I think it is something that I'd suggest can't be divorced from the future of the court itself in this complex, so that the notion of the library being something else is unlikely, in my view, to ever occur unless the court is something, the court building is something else, and the court building is used for another process. This image is just interesting in that it highlights the dominance of the library building in the Melbourne skyline. And there's no question, until the 1950s, the Supreme Court Library stood as the beacon, if you like, at the west end of Melbourne. And it remains, even today, as a very prominent and powerful reminder. In relation to the heritage context, just straightforwardly the various levels of legislation, the EPBC Act, the Environment Protection Biodiversity Conservation Act, the Federal Act relating to heritage, has a national list and a Commonwealth list. It is not included on either of those lists, but I'll come back to that in a moment. It was included on the old Register of the National Estate. That is now dies next year, so that has no statutory standing anymore. The State Act, the Heritage Act 1995, the court as a whole is registered and the library is registered separately. Now, the history of that would appear to be that in the 1970s, when the state introduced the first legislation on heritage buildings, the Government Buildings Register, as it was called, only listed buildings. It couldn't list land. So that what happened was the ring around this building was put on the list, the court was put on the list, but the courtyard wasn't. So that it had two identifications. And so that it is strangely listed as two different listings in the State Heritage, Victorian Heritage Register. Planning Environment Act, it's identified in the Melbourne Planning Scheme, as you would expect. The National Trust clearly recognises it very highly. It's one of the first listings for the National Trust, 1958. The Trust was founded at that time, and so it's one of the earliest listings. And it's identified as an A-grade building. This is the complex as a whole. The reasons for the court's listing, and I think, and the library in particular, and I think it's worth just looking at this a little bit. Architecturally, Grand Renaissance Revival style design, quite a severe design. If you compare it to Parliament House, State Library, other buildings, Customs House, exhibition buildings, this is a building that's built 1873 to 78. It's at that midpoint. It's coming up to the absolute boom of Marvellous Melbourne, so it's a building that the government invested a vast amount of money in. It was one of the major building projects in the decade of the 1870s. So a very important gesture, if you like, of government to law and order. The planning and massing, the pavilion form, the mannerist detailing, the high standard of finish. It is extraordinarily high quality, the finish inside, the mouldings, the decoration, the plasterwork, the joinery. It is an important work of Arthur Ebden Johnson, one-time head of public works, although the design was delivered by Peter Kerr and J.J. Clark. Now, J.J. Clark was the architect-author of the Treasury Building when he was 19. He then finally delivered the City Baths in 1910. So his span of his career was quite extraordinary. Peter Kerr, the architect for Parliament House. So while Arthur Ebden Johnson is generally named as the person associated, those others were very much involved. The library, one of the greatest of Melbourne's interior spaces, and there's no question it is, the landmark quality of the dome. Historically, important 19th century public building, it rates with, if you like, what I'd say the three great public buildings, Parliament House, the library and the courts were the major complexes, and Government House would be the fourth. Largest court complex in Australia built to a single design. There's no question this court outstrips any other court in any state. It is by far the most substantial of these 19th century courts, and extraordinarily impressive in that sense. The continuity of relationship between process of law and building complex is a fascinating and pivotal issue. The court, as you'd be all well aware, is designed with an extraordinary program of separation of the operations of the court and the main stairs, the secondary stairs, the isolated corridors, all that movement system, which was well known about. But this court building particularly demonstrates that separation of activity and function, public, judiciary, jury, etc. Continuity of the collections. One of the things we did in the 80s was actually go through the entire building and identify every single bit of furniture in the building and identify who made it, who designed it. It has one of the best collections of 19th century furniture in Melbourne, along with Parliament House, Town Hall and Government House. The integrated heating and cooling system may seem odd, but it in fact was highly sophisticated. It has, if you've sat on a bench here, underneath the benches there are massive reticulated iron pipes that reticulated hot water all the time. It had a ventilated cooling system that went up into a plenum in the roof spaces above the courts. It was a very, very sophisticated building. And lastly, social significance. Clearly, now, as a living significance, it is of importance to the community for those who participate in activity here. It has less broader social significance, but if you look at the continuum of culture and the community, it does. The library itself is the place that is the third of the domes that were intended for Melbourne. Parliament House dome, designed by Kerr, never built. The dome proposed for the State Library, which was designed by by Joseph Reed, Reed and Barnes, never built. Then subsequently the dome put in for the reading room in the 1910s, and the Supreme Court dome. And these were the great edifices that would highlight on the hills of Melbourne and be seen as you looked across Melbourne. One of the questions about its significance that comes up is, does it warrant national listing? And in our view, there's no question it does. This is a building that should be on a national list. There are 50 sites on the national list at the moment. A substantial number of them are cultural sites, that is, or natural sites, Kakadu, those sort of things. The others are cultural historic sites. And the court, from 1985 to our review in 2005, is a place that one would certainly contemplate as a nationally listed place. And it's a place of very great importance, a class, so we saw it under criterion D, place of outstanding heritage value for the nation's place because of its importance in demonstrating principal characteristics of a class of Australian cultural places and a class of Australia's cultural environment. So it is a place that in time one would contemplate, if you were looking at its future, you would say it is highly likely this would be listed nationally. Which has ramifications quite clearly for various reasons. The origins of the court, circular libraries, and part of its distinction is that it's one in a world context of very few circular libraries of this period and of this age and of this scale. In the 20th century, circular libraries became slightly more common, but there's still not many. The earliest one that is known of in Lower Saxony, built in 1706, 1710. This is elliptical, but it basically has exactly the form that you have here. This central area, an ambulatory or annulus running around the perimeter, the occupation of the corners by these various rooms that we use. Bookshelves, in this case, put around the columns as part of the layout. The Radcliffe Camera in Oxford, the next one and the earliest surviving example, and built to a design of Wren that was then taken over by Hawksmoor and finally delivered by James Gibbs. And Pevsner has this lovely comment, the result is wall cases in 8 radial alcoves and upper gallery in a total splendid monumental waste of the whole centre. And in a way that is fundamentally an issue for this place. This is a waste, other than it's absolutely visually beautiful. But in terms of functionality, that is what they're about. And so that, but it sits with the Radcliffe Camera in Oxford as one of the world libraries. It's not, this is not just a Victorian place. This actually is a building that one would celebrate for a lot of reasons. And that's that building, sort of very much sort of Bramantes Tempietto blown up into a very much larger scale. The building that is always seen as the antecedent is the forecourts in Dublin, and there's no question that when Johnson designed this building, he designed, in fact, the drum of the dome exactly as per the forecourts in Dublin. Now, the forecourts in Dublin never used that central building as a library, although it was designed as a library. So it was intended to be a library, but it was never actually occupied. It currently, I think, houses the Attorney General's records. But it is certainly, this building is probably the one that was most influential. And this is a building that is about 19.5 metres in diameter. This building is bigger. So this is actually larger than the library in Dublin. But it would appear that that is, that James Gandon's project here that he delivered is the one that Johnson probably referred to in contemplating this. And those are all 18th century projects. The 19th century projects, Thomas Jefferson's Rotunda at the University of Virginia, and then the great reading room in the British Library, which is now roofed, but this extraordinary complex here. So that what has occurred is that you have in Melbourne a building that stands certainly at the highest level of significance, if you like, certainly in a national context, and I'd suggest more broadly. In looking at just headings, really, and this is where my brief is broad, and I've been broad in my response and not particularly detailed, and I can give you a copy of this. I've got 8 copies of this, but the outcome of this is to present a short paper, so I will be doing that for Sean at the end of this process. This is a sort of midway. If you like, these are my comments in thinking about this, and the first one is just what it's like now, the future, which I was asked to think about. All right, what happens in the future with this? The first comment I'd make is that it is portrait-like and confronting. It's not a building that in any way you feel can get into. It's a bit like the National Gallery. It's this great wall, and you think, well, how do I get in? Should I get in even? It's got a very contained entry point. It's a very, you come in through this narrow point. It's not a particularly, you think, am I in the right spot? Should I go in? It is a celebrated and remarkable piece of architecture, there's no question. It is an unoccupied space. Coming in here during the day, this is not a bustling environment, unless there's something on. James can correct me, but my sense is this is a place that you would occasionally find someone sitting doing something, but other than staff being active, but in terms of users, this is not a hugely active environment. What do you do? What's your response to the building? Well, and I guess these are the questions. How do you occupy and activate this space? This is a glorious space, and you think, should this just sit and be here? Should it have something else? So I suppose that's one of the questions. Should it be made more accessible? Should it be more inviting? Is there, and you've got a barrier here to get to this place. You've got to come through security. You've got to come through a whole set of barriers. When the laneway was active and everyone could walk up and down it, you could just wander into the courtyard. It was a very much more accessible court, in fact, in those days. And it was far more part of the city environment. And sadly, because of security and all the other reasons, it's become increasingly not that. And it's become defensive. And I think when we did the study in '85, I think there were probably 8 entries that were always operating. You could always walk in the entry that was near your court and just go into your court. The courts you could walk into all the time. So it was a totally different context. Celebrate the architecture. There's no question, and I think the court does, but even in the open house scheme once a year that everyone runs, having it open, getting people in here, making it known is no question is part of this future. And becoming a destination, I think that in contemplating its future, it is about, all right, why would people come here, and how do you turn a place that's never been a destination other than for a very small part of society into a destination? People say you must go to the Supreme Court Library and see it, whether you're a visitor to Melbourne, whether you're a local. So they were just prompts really to think about it. And there are 5 sort of key elements. So that's the building. The collection, which I think you've had a talk about, certainly, Barry's collection, critical to the heritage significance of the place. So in the studies that we've done, we've said the fundamental character and presentation of the library would be compromised if it were adapted for another use and or the bulk of the book stock was removed and its density thinned. Now, it's an interesting comment on reflection in that when we have looked at this place over 25 years, we've always said the books are not as important, but they're a very important part of the presentation of the library. And in hindsight, being asked to look at this and saying, well, what happens if there aren't books here? What is this place? And I'd still say it is an enormously important place. The books aren't, it is still a nationally significant place, whether the books are here or not. There is no question, though, the books and the collection are an important part of the place. Now, that collection clearly has 2 parts. It's the legal collection, which is, I assume, James, 95%, and then it's 5%, which is Barry's bizarre, unusual collection of his books, and then other things. And so that I think in contemplating the future, there is the issue of what you do with the collection, how you think about the collection, and what it does in terms of the library's significance. We briefly looked at the arrangements in New South Wales, South Australia and Queensland, and it's interesting, all the court libraries vary in different ways, and I'm sure you're aware of this, but some of the courts are combined in other states and have a single central library. Queensland has a statutory corporation for its library and it runs it in a quite different way. It actually publishes and does all sorts of things. So the models, there's no one model, one would have to say, in the way that it's approached. The present in relation to the collection, other than to the legal profession, largely uninteresting. Not many people are going to come and browse through reams of serials of laws and cases. The Barry collection is rare and intriguing. The Barry collection is an astounding collection and at a state level is incredibly important, as the court realises. But it probably shouldn't be here. It probably should be actually somewhere where it can be looked at, used, observed and got at, rather than simply sitting in a room there and collecting dust, with no disrespect to everyone here, but in reality that is what happens. So that the Barry collection, and you've had a talk about this, is something that is terribly important and I think needs a lot of thought. The whole collection is important, the building, and then you've got objects and art, and that is part of this. The future sort of thoughts broaden and diversify. Do you augment this and bring in a collection that makes this more attainable and more interesting to others? Is that appropriate for a Supreme Court library? Do you relocate the bulk of the collection? Could the bulk of this actually end up simply in stack storage somewhere and be accessed remotely, much as the State Library or the Baillieu Library or any of the libraries that have endless bound serials that are accessed on occasion rather than constantly? Do you develop a specialist collection? Do you go to the State Library and Baillieu Library and say, we will take your rare books, we'll turn this into Melbourne's repository of the most valuable rare books in the state and people can come and study and use it. And I'm being sort of lateral in all of this just to toss things on the table, but I think I can't quite conceive this being here in 20 years' time like this. I think this collection by then will have been surpassed by soft copy. People will be able to get stuff online and someone to come and sit and open a book and read it to get something from it, I suspect will get increasingly rare over that time frame. Expand to include artefact material, court records, objects, the issue of curatorship. Queensland certainly does that in their libraries, I understand. They have artefact material. The whole notion of the library becoming something more than just the library, becoming not the museum of the Supreme Court, but becoming something that has more, that would attract people and attract custom. And so it is about broadening the exposure. The dangers of this, the Mortlock Library in South Australia, if you've been in, weddings and wallpaper. It is simply used for weddings and all the books that are there are 1-cent copies of things that you'd throw away tomorrow. No one ever reads them or takes them out. They are simply wallpaper. And it is the tragedy of these spaces in a way, because once you remove the function, these libraries can't function in a contemporary accessible library sense. They don't comply in any way with regulations. You can't access anything. You can't monitor them or police them because people hide behind projecting bookshelves, etc., etc. So this is abandoned, effectively. The State Library of South Australia is a beautiful library, but it operates out of a brand new building, not out of this building. And this sits there as part of it. So I think that there are dangers in thinking about this. The issue of use, and again, this was something that was flagged as a matter to be thought about. Historically, the library was established for the legal profession and the courts. In general, there were no other court libraries. The magistrates and county courts didn't have libraries. Essential resource component of the legal process. The historic role is unchanged, level as use is diminished, related availability of resource online, legal practices, etc. I mean, that's over a long period. That's not just suddenly, obviously, that's changes. The Library of the Supreme Court's distinguished a repository of historical case histories, resources generally unavailable elsewhere, and certainly in talking to James, in discussing how much is on soft copy, how much is on hard copy, and how long will that take for that hard copy to catch up and finally be copied into soft. Those sort of discussions, expectation that there may be series here that are never in fact put on soft copy because they're used so rarely that no one's going to pay to do it, in which case they do become important as retaining them. The library serves as a venue for court functions, reception space for legal conferences, etc. The future having changing patterns of use affected the relationship between the courts and the library. I think it's interesting to contemplate this whole issue of, if this isn't just a library, what else is it? And I know the court's increasingly beginning to promote, I think, this idea that this can be used for as a venue, essentially, which is not unlike any number of organisations that have spaces that they think, what do we do with? The State Library, when we did the recent study on Queen's Hall, which sits vacant to this day, we looked at a major venue component to the use of Queen's Hall. So a place for hire, basically. You can have your wedding, you can do whatever. Now, that is not perhaps at all appropriate for the court, but I think that part of the discussion of use is to be lateral about the way the thinking might go. So the present use, the court itself, the legal profession, students, and I'm not sure how many legal students do actually use this, whether some, and it's got some controlled venue use. The future at the moment is the court, a place for study. It's interesting with VUT, with its campus in Queen Street, its main legal campus, whether the court actually starts engaging directly with that campus and is actually encouraging in some way of making a link there. General public, why would they visit? One of the issues about the future is it appropriate general public come in? How do you attract them to come in here, though, other than coming in and looking and thinking this is a wonderful space? I suspect there needs to be more of an attractor than that to get people to come here. Venue attendees, obviously. Essentially, the future use users is very much dependent on where the court goes, I think, in terms of the totality of the court itself and the way that evolves over time. Operation and use, just really the same issues, impact of soft copy, critical to the court. So it plays clearly a very fundamental function now. The future, I was contemplating equivalent spaces, and those are some of the equivalent spaces in Melbourne. Queen's Hall and Parliament House, Customs House Long Room down in the Immigration Museum, Queen's Hall and the Dome Reading Rooms, the Cathedral and Gothic Bank, the War Room at Government House. Is their existence enough to warrant their conservation? I suppose the question is, governments have these buildings, no one will ever demolish this, but equally governments increasingly are reluctant to spend money on them. They don't maintain them, and that's the challenge really. And if you look at what's happened over time, it's interesting looking at this space. This is the old 333 Collins Street, the old Commercial Banking Corporation's building, where the dome was left, and it's a foyer basically now. It's just a large, glorious foyer to a high-rise building. So the redevelopment sustained the refurbishment and sustains the space. The long room in the Customs House has one object in it. This is before it was put in. It is one of these sort of great 19th century spaces of Melbourne, and it was kept when we did it. It was kept very pristine, and this object was put in. Jeff Kennett wanted it turned into a function centre. His delivery of that was as a function centre. He said that's what it should be, and so luckily it wasn't, but because it is another one of these great spaces. The Gothic Bank, the Cathedral Room, when we worked on this room has under its in perpetuity a requirement for the bank to maintain it as a public space. They cannot occupy it. So that the permit issued when the development was done was to do that. And it sits, again, as simply a space that people experienced walking through that complex. It is used occasionally for exhibitions, but relatively rarely. But it is another one of these spaces, and Queen's Hall in Parliament House, a space, again, that is very infrequently used in practice. I mean, people walk through it all the time. It's a major space, but in terms of a deliverable function, it is limited. So just really to bring it to an end, I think that, without Sean asking me directly, I suppose, the question is there a heritage constraint that would inhibit what's done in the future? And in a sense, yes, there clearly are, and they're self-evident in many ways. But I don't think that that constraint is such that you can't think laterally about looking at this place, and that you shouldn't be looking at it laterally. I think you should and must. And in how you further get this space to engage with the community of Melbourne in some way. Because I think that, in a way, is the challenge. It's to say, look, we are here, we're really an extraordinary space, and we'd like to invite you in. It's difficult. I mean, there's no question the whole nature of courts, the facility, the security, etc. But were this court perhaps ultimately to become not a criminal court anymore, it was to become a civil court only, and therefore perhaps security is different, perhaps it is more accessible, all sorts of things can be thought about. When the last round of works were done, my memory is that Bob Sinclair, the design architect, when we were all working on this, wanted to put an opening in this east-facing wall, opening onto the courtyard. And in fact, when I was here the other day with my partner, we were thinking, well, do you put a cafe, in fact, in the back space there, open it onto what is a beautiful courtyard, and I suspect not used very much, and actually activate it by simply putting something in that attracts custom. Not unlike the coffee cart outside the county court. Now, I'm sure there are all sorts of politics to do with that, so I won't. But it was an interesting notion that, again, you have a really wonderful space out here that I suspect is not actually occupied very much, other than by the occasional court users. And so there are ways of thinking about how you might physically intervene and not just treat this as a totally hands-off. So look, I've gone somewhat over time, I suspect, but that's really an overview of what I think we've been asked to look at, Sean, and as I say, what I'll be doing is producing just a brief paper, really, that brings that together in some form.